We are a country of laws. Our courts are supposed to make sure they're enforced. But funding for North Carolina's court system hasn't kept pace with our state's booming population. Our focal point, a court system that judges and district attorneys say is overwhelmed, and how that threatens our communities, our families, and even your safety.
Shut the back door, please.
Today, Durham District Court Judge Craig Brown will handle 400 cases.
Ladies and gentlemen, if you called the matter for trial or for probable cause this morning.
Misdemeanors, felony first appearances, bond hearings, and motions.
The caseload continues to grow, and we get no additional resources.
Okay, if you give it to the district attorney. So
Chief District Court Judge Elaine Bushfan says it's impossible to give each case the individual attention it deserves when each judge handles an average of 300 cases a day.
So you're talking 40 cases an hour.
Cattle call.
That's 90 seconds a case.
Something's going to get continued.
Now be quiet. Work is still in session.
It's really an astounding situation over there. They're in violation of fire code every day.
Astounding, but not unique.
Slide all the way against the wall. Keep the hallway open, please.
This is the hallway outside District Court in Charlotte, where the DA says judges also handle about 300 cases a day.
It takes us a while to get through, so we would appreciate a little bit of patience on your behalf.
The numbers stagger me, and I've been doing this a long time.
Well, I think we better hold on to him. I'm going to leave his bonds where they are. Do you have a record?
That's really not the way to run a justice system. I think sometimes we ought to be processing Krispy Kreme donuts, not people charged with criminal offenses, but the volume is so high and the amount of time available is tight.
Well, I assume the lawyers are at calendar calls.
This year, Gilchrist has only 5 assistant DAs to handle nearly 70 murder cases.
They obviously cannot deal with a volume like this.
Joshua O'Brien.
The backlogs force DAs into trial triage. Only 2% of felony cases in North Carolina go to trial. The rest are disposed of through pleas or dismissals.
And in many instances, they are pleading out cases that should not be pled out. That's putting people on the street who should not be on the street.
Perhaps it's a good thing Lady Justice can't see what the system's come to be.
People lose faith in it. They see a district attorney having to plea bargain serious cases. They see us having to routinely reduce charges to lesser charges. They see us having to dismiss charges, and I think this is all corrosive to the public's perception of what we need to be doing for protection, for public safety.
During campaigns, politicians often promise to crack down on crime, but rarely do they include funding for the courts as part of their platform. It's not the kind of sexy issue that gets people fired up, unless, of course, they know firsthand what happens when the courts aren't working as they should. As the courts continue to work and try to keep up with the increasing caseloads, the people who work here have to find new ways to do more with less. They say technology could help, but the technology most of us use every day isn't being used in most courtrooms. State budget, the Administrative Office of the Courts, or AOC, requested about $14 million for new technology and about $5.5 million to replace old office equipment. The legislature didn't approve a dime for either.
It isn't because we lack a vision that this technology isn't in the court system. It's just that we lack the checkbook. We need the money to do it. We've got good people here. We know what to do, but we can't get started on the projects without some funding.
Our Constitution says our judicial system is supposed to be an independent and equal branch of government. But for every dollar North Carolina spends, only about 2 cents goes to the courts. And it's the legislative branch, not the judicial branch, that decides where that money goes. Some say that undermines our Constitution and allows politics to taint funding decisions. In 1996, North Carolina's Commission on the Future of Justice and the Courts called for major reform for the state's judicial system, including investments in technology and innovative programs to resolve disputes outside of court.
Pay a fine of $10 on the call.
It also said the court system should have more control over its own budget. Former Wachovia CEO John Medlin chaired the commission.
A sound and effective judicial system is essential to civil society. It's essential to having a good economy. It's essential to having political democracy.
Who's your lawyer?
Nearly a decade later, there's been little reform.
I'm going to do a second calendar call.
Caseloads have increased while funding as a percentage of the state budget has decreased.
It's being operated on a shoestring.
Rhoda Billings was vice chairman of the commission and a chief justice during the Martin administration.
If we don't have a court system that can provide a day in court, an opportunity for a fair, timely hearing of a case, then we violated the North Carolina Constitution.
Had since June to save you money, haven't you?
Billings and Medlin say the system needs more money.
We don't need budget-busting money.
The AOC wants the system funded at 3% of the state budget, or about $500 million. Right now, funding is at about 2%, or $343 million.
North Carolina ranks 48th in the United States for judicial branch funding. Only Alabama and Mississippi are lower than North Carolina. That is frankly an insult and shameful to the progressive history of this state.
Oh yes, oh yes, oh yes.
Chief Justice I. Beverly Lake believes the legislature's refusal to increase court funding is payback for the Supreme Court's rejection of the legislature's redistricting plan in 2002.
Is it that political?
It is. It is that political.
Lake says lawmakers even took away funding for the armed marshal that protects the justices and threatened to cut funding for half their clerks.
It was clearly tied to the redistricting decision.
When you saw that happen, what did you think?
Well, how little can grown people be?
That is one of the charges that you have. And
Lake has threatened to shut down civil courts so that criminal courts can catch up with the backlog.
I don't want to do it, but we may have to do it in certain areas.
So if you think of that day and that time.
Senator Mark Basnight responded to that by saying the courts need to do more with what they have, saying, quote, I would say efficiencies would have to come in before we apply more money.
Senator Basnight is a good friend, but he simply does not understand how we work.
Lake and others say the courts could operate more efficiently with better technology.
Pursuant to the authority vested in the governor.
Some say court costs could also be cut if the legislature funded more alternatives to traditional litigation.
Judgments continue to pay with the cost.
But court officials say the problem isn't just the amount of funding, it's the method of funding. The legislature, not the AOC, controls the court budget, line item by line item.
And they've appointed judges where we didn't need any judges, and they failed to appoint judges where we did desperately need judges.
30 days to pay the costs.
The AOC says if it controlled its own budget, it would have the flexibility to put resources where they are needed the most. But some legislators aren't sold.
They need to make a case for it. I haven't seen them make a case for it.
Some say the case is written in the state constitution, which calls for an independent judiciary.
It really can't be said with a straight face that we have a truly independent judicial system in many respects in this state.
Come in the courtroom and shut the back door.
Or that our crowded courts are living up to their constitutional mandate.
Justice shall be administered without favor, denial, or delay.